Hi, I'm Andy Harris, an attorney with Maddin Hauser. In this video, I'll walk you through the remedies available when a tenant defaults on a commercial lease and explain how taking the right steps early can make all the difference. If you're a commercial landlord, you know that even the best tenants can sometimes default. The most common default is non-payment of rent, but default can also mean failing to maintain insurance, abandoning the property, making unauthorized alterations, property damage, or breaching an exclusivity or use clause. When that happens, landlords need to be ready to quickly yet properly enforce their rights and avail themselves of the remedies provided by the lease and Michigan law. There's a right way and a wrong way to respond to a tenant in default. Today, we'll discuss the remedies available to Michigan commercial landlords when they do things the right way. The first thing to be sure is that the tenant is actually in breach. Your lawyer can help you make and confirm that legal determination. As I talked about in a prior video, how and when a landlord notifies a tenant of an alleged breach can play a huge role in whether they will succeed in their efforts to evict the tenant or obtain other relief. Most commercial leases require the landlord to provide written notice of default and, in certain circumstances, to give the tenant a set amount of time to fix or cure the problem. Following any notice requirements to the letter is essential if you want to obtain any of the following remedies. First and most final is the termination of the tenancy and repossession of the premises. You can terminate the lease, recover possession of the premises, and remove the tenant. If the space is already vacant, it's certainly much easier, although litigation may still be prudent in this circumstance to avoid any notion of abandonment. Oftentimes, you'll need to file a lawsuit under the Summary Proceedings Act in district court. Keep in mind that even after termination, the tenant may still owe you damages for unpaid rent or other losses. Acceleration of rent under the lease may also be an option. Some leases include an acceleration clause, allowing landlord to declare all remaining rent due immediately upon default. Courts in Michigan generally enforce these clauses if they're clearly written and not construed as punitive, but you'll still need to show landlords acted reasonably and in good faith. On top of that, if your lease provides for it, you can recover attorney fees and other costs you've incurred trying to enforce your rights. Given the importance of your lease's notice and cure provisions and following them to the letter, you should consult with your attorney for making any action against a defaulting tenant. That will give you the best chance of obtaining the relief you want. If you're a Michigan landlord facing a tenant default, I can certainly help you understand your options, protect your investment, and move forward efficiently and cost effectively. Please feel free to give me a call.